Hello and welcome to Moneylife. This is Sucheta Dalal. This week, we revisit the Securities and Exchange Board of India, which, as you know, is hugely in the news. And in spite of that, we missed a 22nd November report, or rather order, where the Securities Appellate Tribunal had once again imposed a penalty of 1 lakh on the Securities and Exchange Board of India for what it said was passing a mechanical order against an internal auditor, SRBC and Company LLP. This company was a joint auditor of Infibeam Avenues. I'm going to keep calling it Infibeam. So here's what happened. A whistleblower alerted SRBC, the internal auditor, to apparent violations happening within Infibeam. Based on this information, the auditor correctly sought additional information from the company. Now, instead of complying, Infibeam officials apparently threatened to sack the audit firm and even asked it to resign. SRBC correctly refused to resign. And what happened after that is Infibeam filed a complaint against it, alleging violations under the Insider Trading Act. Now, adding to the problems here was a fact that 2 SRBC employees had inadvertently sent an email containing financial information of Infibeam to a person whose name was extremely similar to the Infibeam CEO. His name was Hiren Patel instead of Hiren Padya. Now, the mistake was quickly rectified when the 2 employees got to know about it. They went to the recipient, asked him to delete the information. But when you're in a fight, all this was brought up, and SEBI apparently was willing to buy it. So SEBI argued that SRBC as an audit firm lacked the mechanism to prevent such inadvertent mistakes, that employees entrusted with auditing sensitive information had a duty to take appropriate care, and they didn't. SEBI also took the stand that once a violation has been admitted, that means you make a mistake if you admit anything, the regulator has no choice but to impose a penalty. They imposed a penalty on SRBC, which filed an appeal. Now, SAT, the Appellate Tribunal, found this argument illogical, and it said so, and also said if this argument or logic was accepted, then it would lead to absurd consequences. This is not the first time SEBI has done something which is callous or absurd. In fact, it's happening a lot of times. And the implications of this order are significant because we already have the credibility of the regulator on test, and it is built on its ability to act impartially, enforce rules without fear or favor. Ethical concerns regarding conflict of interest, selective enforcement, lack of transparency have plagued SEBI for a long time. Those of you who follow Moneylife would see that every once in a while we come back to this. We have done studies at Moneylife Foundation about the quality of orders, of course, not limited to SEBI, also SAT. Now, isn't it strange that the logic that SEBI applied to these 2 employees, that even if you made a mistake, an accident, however inadvertent, even if you corrected it, we will still punish you. This logic doesn't seem to apply to the chairperson. The SEBI chairperson, under a cloud, so many allegations against her, but the government has given SEBI blanket protection, or rather the chairperson blanket protection, even to errors of misjudgment that are apparent in her own statements, the few rare ones that have been issued. Like I said, Moneylife has written several articles on SEBI's patchy record going back several years. Here are some links that we're providing to it, but they merit revisiting today in the context of SEBI's long-term credibility, because this time you have the government jumping in to say, don't look there, everything is perfect. And we think that in the absence of fair play, and the manner in which SEBI even uses public funds and senior law officers to defend itself against any criticism, any negative order, any costs and strictures, it's time to look at it in a different context. Interestingly, SEBI's functioning has attracted comment and criticism, not just from SAT, not just from the high courts, but from the Supreme Court and from the current Chief Justice, Sanjeev Khanna, when he was not the Chief Justice, and someone who's likely to be a future Chief Justice. Listen to this. In the Apollo Tyres case of 2018, Justice Sanjeev Khanna had criticized SEBI for appealing against every order that went against it and directed the regulator to file a list of all such appeals filed against SAT orders on an affidavit. Justice Khanna also sought an explanation from the officer concerned for a delay of 15 years after the alleged violation in initiating action. In 2023, another bench led by Justice B.R. Gawai remarked that SEBI was filing frivolous cases. And I quote, we have seen that rather than doing regulating work, you're only litigating, he said. This case goes back to 2006-9 period. It's happening in 2023. And it is not a singular case. SAT has frequently overturned SEBI's orders, citing procedural lapses, disproportionate penalties, lack of due diligence. Let me give you some illustrative examples. So 2020, Naman Charan Biswal versus SEBI. SAT had criticized SEBI for passing an order without application of mind and imposed a penalty of 50,000. SEBI appealed, got the costs waived, and got the adverse remarks expunged, even though this was an extraordinary case of repeated miscarriage of justice, where Mr. Biswal's name was misused by a dodgy company called NISA Technologies, and he ended up being harassed for over 5 years, not only by SEBI, but also by the Ministry of Corporate Affairs, and incurring huge legal costs. SEBI fought against giving him any of those costs. Doesn't matter how much of harassment he faced. Another company, Deol Shaha versus Harish Chandra Gupta, 2014. SAT criticized SEBI's callous attitude, leading to unnecessary litigation. Here, the case underscored SEBI's failure to exercise proportionality and discretion. Another case of 2021, Yatin Padia HUF versus SEBI. SAT accused SEBI of judicial dishonesty, reflecting poorly on the regulator's integrity. In fact, the tribunal's scathing remarks pointed to systemic flaws in SEBI's decision-making process. Another egregious case of 2019, Sanjay Gupta versus SEBI. SAT had imposed costs on SEBI for mechanically passing a harsh and unwarranted ex parte order that continued for over a year, was confirmed without application of mind and without considering relevant documents. We have written separately on this. You can look it up. There is a link. What is significant about this order was that it was passed by a whole-time member who is now the SEBI chairperson. Far from being embarrassed, SEBI's counsel immediately asked that this paltry cost of 50,000, which was imposed by SAT, should be waived on the grounds that it would have a negative effect on the organization. Clearly, there's no negative effect. The WTM became a chairperson and is now being vigorously defended by the government. There are plenty of other such examples. One could go on and on. One more is Advent Finance versus SEBI 2016, where SEBI was imposed with costs for apathy, leading to prolonged unnecessary litigation. There was Umashankar Agarwal versus SEBI 2018, where SAT remarked, this is interesting, we sincerely hope that SEBI would take appropriate remedial measures in the matter and ensure that its credibility as an efficient market regulator is not eroded. It said it was refraining from imposing heavy costs on the regulator only because it had remanded the case back to SEBI for fresh orders. A recurring criticism about SEBI is its tendency now to appeal every order against it, as the Chief Justice pointed out, even when it is completely in the wrong, and then it hires expensive lawyers or powerful legal firms, often the Attorney General or the Solicitor General, and they have influence in court, so it ensures that strictures are expunged and these costs are waived or removed at the Supreme Court level. In fact, in the Polo Tires case, the Supreme Court had wrapped SEBI for indiscriminately appealing SAT decisions that highlighted delays and inefficiencies in its enforcement order. The same issue is at the center of the Adani controversy. SEBI has got away with it consistently using public funds. Remember, it's a regulatory body. So when it hires the most expensive legal minds, it is the regulator, which is collecting fees from people and is funded by the government, that is paying the cost for this. only time ever that SEBI has apologized to the Supreme Court is a case when SAT set aside a 25 crore penalty on the Ambani family because guess what? Not because they're the Ambanis, but because it retroactively applied regulations enacted in 2015 to a violation that was alleged in 2000. But here too, SEBI did not hesitate to appeal. It's only when it looked like the Supreme Court is going to get really angry that it apologized and withdrew. Now, look at the double standards that the regulator employs. Lack of oversight over SEBI by the Parliament and Finance Ministry is what emboldens the regulator because it gives it unfettered power and allows it to employ these double standards while dealing with regulated entities. This is a fact noted by almost everybody who practices securities law, and many of them are people who have previously worked with SEBI. For instance, Advocate Sumit Agarwal has written an article in Bar and Bench where he points to SEBI's contradictory stand on recovery of legal costs. He says, on the one hand, SEBI repeatedly questions SAT's jurisdiction to impose costs. You also heard how it said it will have a negative impact. And even when its own actions have led to egregiously unfair decisions, hardship, loss of business, it wants no costs imposed on itself, even when the orders are thrown out lock, stock, and barrel. At the same time, SEBI does not hesitate to impose costs. So it has imposed costs on the National Highway Authority of India. So on one hand, it says, we are a regulator, so SAT can't impose costs on us. But when another regulator is also regulated by it, NHAI, it imposed costs. Now, let's understand. SEBI did the right thing in imposing costs. It had given repeated warnings to NHAI. NHAI did not comply with listing regulations. It was the right thing. All that we are saying is the same should apply to SEBI. Does something wrong, orders are bad, harasses people. If costs are imposed, it should pay up because litigants, investors, people who are harassed have a right to get back their legal fees, especially when SEBI recovers legal costs from investors and market participants, even when they enter into settlements. Now, you know what a settlement is, where you pay a big sum of money, not so big in India, without admitting or denying wrongdoing. Now, in these cases, all the work that is done, SEBI is apparently recovering legal costs, what Mr. Agarwal says, and he has worked at SEBI, he should know. He also says that these costs are not credited to the Consolidated Fund of India, but remain with the regulator. So what is, fair for SEBI is apparently not applicable to other regulated entities who are victims of SEBI. Importantly, SEBI's expensive legal battles, important to remember, are funded by public money, and the representation comes from officials, so it works. Now, who's going to question the regulator? Since the finance ministry is so busy defending SEBI against even legitimate questions in parliament, who's going to do things like doing a cost-benefit analysis on the waste of public resources, how funds are used, are people harassed? In fact, they're using this money only to defend SEBI against strictures by SAT or the high courts. All this can be stopped, corrected, if there is a study or if there is an attempt to prepare an objective framework of proportionality that aligns penalties and settlement amounts to the severity of violations. There has to be a precedent, there has to be categorization. We have said this in our studies also. There is nothing. Similar offenses can have hugely different settlement amounts and hugely different penalties because what one WTM does, the other doesn't even pay attention to within the same organization. Now, far from blocking a discussion about SEBI, the finance ministry needs to make the regulator more accountable through enhanced disclosure of enforcement actions, have timelines for its investigation, manage conflict of interest, which is at the center of the current controversy, and ensure that there's greater parliamentary oversight. It is the job of parliament and our elected representatives to ask questions, and only when the regulators are questioned will they stay on the straight and narrow. Failure to do so erodes not only SEBI's credibility, which, if you ask me, is pretty low today, but erodes investor confidence not only in India, but across the world, because we are an important capital market today. If you agree, please lend your voice to this, share the video, and of course, subscribe. Thank you.